Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammi. I am Executive Director and Vice President for Legal Studies of Washington Legal Foundation. And for those of you not familiar with the foundation, we are in our 47th year of advocacy and education on a pretty wide range of issues in support of a free market mission. Our website is wlf.org. I encourage you to spend some time on there if you'd like. This is the third in a series of programs called Tech in the Courts that we're presenting in partnership with TechFreedom. Tech in the Courts will examine key topics at the nexus of technology and law. TechFreedom is a nonprofit, nonpartisan technology think tank launched in 2011. The organization seeks to advance public policy that makes experimentation, entrepreneurship, and investment possible, and thus unleashes the ultimate resource, human ingenuity. So in the 1964 Disney film Mary Poppins, the character Mrs. Banks pleaded with her quitting nanny to think of the children. 32 years later, an episode of The Simpsons satirized Mrs. Banks's plea, with Helen Lovejoy pleading during a moment of perceived civic crisis, "Will someone please think of the children?" Politicians and regulators for years have been embracing this concept of protecting kids to justify all sorts of government action. Today's webinar focuses on one of the latest attempts to seize the moral high ground. I'm pleased to hand over the moderation reins to Ari Cohn, who is a free speech counsel at TechFreedom. Prior to starting his own practice, Ari spent nearly 6 years defending free speech at the Foundation for Individual Rights in Education, where he served as director of its Individual Rights Defense Program. Ari began his career at the Chicago office of Mayor Brown, representing clients in complex commercial litigation. Please be aware that we are recording this program. If you have any questions, please use the Q&A function in the Zoom webinar toolbar, and Ari will try to get them to them at the end of the program. Ari, I am pleased to hand it over to you.
Thanks so much, Glenn. Good afternoon or morning, as the case may be. Thank you all for joining us. We find ourselves at a moment in time that is both new and very not new. Every new communication technology and medium of communication, all the way back to the written word, has inspired fear and panic about the ways in which they might entirely unravel civilized society and lead us to our collective doom or something like that. And those fears are particularly of great force when they focus on the impact on and the well-being of children. And so it came to pass that society's fearful gaze eventually and inevitably turned to the internet. In general, as the internet provides unprecedented access to the universe of information and content out there, not all of which might be appropriate for children, but also more specifically, unless you've been living on a remote, isolated island for several years now, and if you were, I question your choice to return, you've heard from any politician within 100 yards of a keyboard or microphone that social media is literally killing kids. Literally. The concerns are varied from inappropriate content to alleged addiction and depression, self-esteem issues, child predation, bullying, etc. And I'll be so bold as to presume to speak for the panel. And I think all of us agree that protecting kids is important and kids should be safer online. If any of you are brave enough to say I'm wrong about that, please let me know. But the much more important question is how. And the throes of moral panic often lead to a truncated thought process in answering that question, which goes something like, something must be done. This is something, therefore we must do this. And that's usually about the amount of thinking that goes into a lot of proposals. Dozens, if not hundreds, of bills aimed at protecting kids online have been introduced in Congress and state legislatures across the country. And a crucial component to many, if not most of those efforts, which we're here today to discuss, is age verification. And I am truly thrilled to be joined by an esteemed group of panelists today. It's one of life's lesser recognized pleasures to moderate for panelists who are much smarter than yourself. So I would like to introduce them to you now. Kate Ruane is the director of the Center for Democracy and Technology's Free Expression Project, an attorney with a strong background in legal research and free expression issues. Kate is committed to the freedom of speech and bringing focus to the ways in which strong protections for free expression benefit oft-censored groups. Most recently, Kate served as the director of U.S. free expression programs at PEN America, and prior to that was senior advisor for the First Amendment and consumer privacy at the ACLU for 3 years. And she spent 11 years as a legislative attorney for the Congressional Research Service, something I am particularly jealous of. That sounds like a great job. David Greene is staff attorney and civil liberties director at Electronic Frontier Foundation. He has significant experience litigating First Amendment issues in state and federal trial and appellate courts on a variety of different issues regarding digital civil liberties. David currently serves on the steering committee of the Free Expression Network and the governing committee of the ABA Forum on Communications Law. He's also an adjunct professor at the University of San Francisco School of Law, where he teaches classes in First Amendment and media law. And last but certainly not least, Vera Eidelman is a staff attorney with the ACLU's Speech, Privacy, and Technology Project, where she works on the rights to free speech and privacy in the digital age. She focuses on the free speech rights of protesters and young people, online speech, and genetic privacy, and she is, in fact, deeply involved with some current litigation before the Supreme Court on age verification. Before joining the ACLU, she served as a law clerk to the Honorable Beth Labson Freeman of the U.S. District Court for the Northern District of California. Thank you to all three of you for joining us today. It's a pleasure to have you. So I mentioned just before a global abstract reason that this isn't really new ground, but there's also a more specific way in which we've been here before. The idea of verifying internet users' age goes back to the early days of widespread internet adoption. And it came up really in a much similar way, legislative efforts to protect kids against bad things on the internet. And the legal battles that transpired, in fact, helped shape how the First Amendment applies in the digital age and its interaction with the internet. Vera, since the ACLU led the charge in challenging those laws all way back in the day, I was wondering if perhaps you could give a really brief oral history of the previous attempts at online child protection laws of yore and how it played out.
I will try, and I appreciate the question. I should also note that though we have the pleasure of being in many of the case names, a lot of the organizations that are also on the panel, and I'm sure in attendance, were also critical to just as involved in bringing the cases and getting the wins. But I think, Ari, you're exactly right that not only have we been here in theory and in concept in terms of moral panics trying to protect kids, including specifically from indecent or harmful material on the internet, but I would argue, literally been here with essentially identical laws. And I think the two seminal cases for this, at least at the Supreme Court level, were Reno versus ACLU and ACLU versus Ashcroft. Reno versus ACLU was decided in 1997. If anyone wants a fun reboot on what did we know, or what did the Supreme Court justices know about the internet back then? I was just reading it. It's really fun. It talks about like internet cafes. That's how we had access to the internet and cafes back then. And the law at issue there essentially made it unlawful to distribute obscene, which ends up being okay because that's literally unprotected speech, indecent or patently offensive material to minors on the internet, absent age verification. And that opinion ends up being very important, Ari, as you said, in establishing that the First Amendment very much applies to the internet as a new medium of expression. It is cited in basically every case about the internet and the First Amendment's reach to protecting things that happen online. And it also specifically says that that kind of regulation of restricting what adults can see online, because that's what happens when you restrict the internet in the name of protecting kids, is unconstitutional if it reaches too broadly. It subjects the law at issue there to strict scrutiny and says it fails because there's more narrowly tailored ways to get at protecting kids. And essentially the same thing happens in ACLU versus Ashcroft about 7 years later, which is a law that perhaps more narrowly gets at quote unquote harmful to minors material, which is a term of art that comes from Ginsburg versus New York, which essentially defines speech that is obscene when seen from the eyes of minors. Question if that means a 17-year-old or a 7-year-old, but that is a question for a different set of cases. And that case, again, is about a law that makes it criminal to provide access to such material online to minors unless you try to verify the ages of users. So it squarely brings, as Reno did, this question of what age verification does to the First Amendment rights of adults, and I would say also kids, and also discusses the inefficacy of age verification, the ways in which it is certainly not the narrowest way to get at, as you said, a harm that we all think is important to try to address. And yet here we are 20 years later. So I will turn it back to you.
Yeah, and one thing I really appreciate that you noted is the note that this affects adult speech as well, and it should surprise absolutely no one to learn that the vast majority of users of social media, and in fact the internet, are adults. I think conservatively 75% of social media users are over the age of 18. So we're talking here about regulatory efforts and legislative efforts that actually regulate the internet for kids, for everyone. And we'll discuss that a little bit further, but I just wanted to call out that good point. To just do a quick one more moment of table setting, I mentioned the myriad legislative efforts to protect kids online, and it's worth just briefly noting the broad categories of the types of legislation we're talking about. So relevant to this discussion, there's about 4 main categories. There's laws that seek to prevent minors from viewing inappropriate adult content online, like Texas HB 1181. There are laws that either ban minors from social media entirely or require parental consent before they can have an account. There are laws requiring social media platforms to design with age appropriateness in mind, like California's Age Appropriate Design Code and other similar bills. And there are laws that impose liability for harms resulting from the use of social media. For example, the Kids Online Safety Act. That's really, not comprehensive list of all the different types of legislation, but to give you all a good idea. So some of these bills outright say you have to verify users' ages. And so we know we're talking about those. But I also want to nail down the bills that either say explicitly, we don't want you don't have to age verify, or just kind of silent, but requires certain actions with respect to minors. And I'm thinking of things like the Kids Online Safety Act in the Senate version that had the language, actual knowledge or knowledge fairly implied on the basis of objective circumstances that a minor is a kid. So these laws don't explicitly require age verification, but is that practically so? Kate or David, do either of you have thoughts on that?
Well, I guess I'll start and then let Kate follow up. Yeah, I mean, so we see a lot of laws that either impose a negligence regime or a really low mens rea requirement on platforms if they either provide certain features or allow minors to access content. So, for example, saying that the law might say that you must take reasonable measures to prevent minors from accessing certain content. So that's not a direct age verification requirement, but certainly a platform trying to decide whether or not it's going to take the risk of being found negligent for not acting reasonably. The thing they're most likely to do is to pose age verification on all of their users, because that would be really the only practical way to manage that risk. I think the California Age Appropriate Design Code, which was struck down, at least in part by, and I say in part because it's been sent back for some further consideration, and actually sent back and one of the things it didn't touch on was the age verification. One of the things the Ninth Circuit didn't touch on was the age verification provision, unfortunately, which is an unfortunate omission. But that required online businesses to estimate the age of child users to the extent proportionate to the risks arising from the business's data practices. And we see this a lot in laws because there's this idea, and I think there's some truth to it, that social media companies in particular have already estimated the age of users, and then they use that information in terms of what content they recommend to users, and so they should use that same data. there's, the problem with that is you're taking something which is a practice designed for one purpose, you're giving it the force of law to require them to actually be much more precise, because these laws typically will draw sharp lines in terms of age. It either, defining users either 18 or defining using 17 at the age majority, which is in order to be more consistent with Reno versus ACLU.
Yeah. Oh, sorry, Kate, go ahead.
I mean, the only thing I would add to that is I agree with David that there's a sort of sleight of hand going on in some of these bills that don't mention age verification, and it is because it is incentivizing that. But the other thing that like David kind of touched on, but I wanted to state more explicitly is I think some of the bills that don't mention age verification are kind of, being pretty I don't know, pedantic about the word verification. and instead are incentivizing age assurance, which I would equate with guessing how old people are in order to determine whether they can access constitutionally protected content.
Yeah, and we'll see age estimation, age assurance. You see these terms both throughout legislation, regulation, as well as the industry itself that develops these technologies tends to use these various terms as well.
Because they are not verifying anybody's age. They are telling you, we think this person, based upon XYZ factors, is probably within an age range of 18 to 25. And so, like, because they are within that range, if you want to provide them access to your service in order to ensure that you aren't violating a particular statutory provision, we recommend you go through additional processes of collecting additional information to obtain actual verification.
Yeah, I think my favorite permutation are the bills that say you have to verify age, but then talk about how age assurance is, one route that platforms can take. Well, if you're just doing age assurance, like you said, Kate, you're not verifying anything. So it's kind of inherently inconsistent. I think the takeaway here from my perspective is, from listening to you guys and from having, been rolling around this issue for the past 3 years or so, there is no way to treat minors differently unless you know who the minors are. And if there is punishment for not treating minors in a particular way, the only sane, logical, risk-averse solution for social media platforms to take or websites to take that are covered under other laws is to do age verification. And at that point, there might even be a valid argument that when the platforms do that, it has been effectively mandated because it wasn't really a choice that the platforms had. And maybe then you get into a state action problem of, okay, does this bill actually effectively mandate it? That probably is a slightly tougher hill to climb, but who knows? So getting to the actual problems with age verification, now that we've kind of laid out a little bit of what we're talking about with more specificity, the courts in the cases that Vera mentioned earlier, they isolated a few top level big problems with age verification. One of them is technical. The affirmative defense for websites or services that age verify users was found to be effectively unavailable. And it said that because on the internet, nobody knows you're a dog. There was, back then, credit card numbers were the way that most people verified ages, but nobody really knows who put in the credit card number. Has that changed at all? Has technology obviated that problem?
So technology has advanced beyond that, where I think where it's being solely credit card linked. So technology has changed. I don't think technology has solved the problem. I don't think anybody, even the vendors of age verification tech, are saying they've solved the problem. I think they'll say that sites need to use a variety of different tools. So, and And these tools really range. There are some that are based on that do age estimation by facial scanning. There are some that do basically by by assembling profiles on users from data brokers. For example, there are some that will require driver's licenses or other type of documentation. There are some that are linked to devices that are operating system based. So so there's a wide variety of things. But there's nothing that says that these things are highly accurate, especially for someone who has to make a decision between someone who is, a day short of 18 and a day beyond 18. Like there's nothing that can do that. And I think the other point is that all of these things are really fraught with privacy issues for users that make it very difficult to use the internet anonymously, make it very difficult to share a device, with somebody. And I say that's ironic because many of these laws see themselves as privacy protection laws. We're doing this to protect the privacy of young users. At the same time, they are forcing all internet users to sacrifice their privacy to use the internet. And that's I always see as the grand irony of these schemes.
Sorry about that. It strikes me that, even the most secure, or not secure, but accurate form that you can think of, say, uploading a driver's license and then also having to do selfie verification. There is no meaningful difference in terms of being able to use someone else's information. It is just as easy to pass the phone to your sibling and have them put in their information and use their face as it is to enter somebody else's credit card. I haven't seen a way that we can ever actually ensure that the person submitting the verification information is who they say they are. And I'm not sure how that could ever be resolved. Perhaps somebody will come up with something someday, but that strikes me as a really hard problem to fix.
I think that's right. And just one thing that I think David said, but I, like Kate, would like to echo is not only that this creates an additional privacy problem, but I think an even deeper irony is that it can, and I think in fact does create a bigger privacy problem for kids specifically. I think this is a point that EFF makes very effectively in their amicus briefs about how actually kids' social security numbers, for example, are uniquely appealing to identity thieves because they haven't really been used before. And so requiring kids to have to try to verify their ages in order to, for example, then provide consent from their parents exposes them to new and significant harms.
Yeah, and that's a great lead in to a second gigantic glaring problem with age verification, which is exactly that, privacy and security. Back in the mid to late 90s, there wasn't really as much data collection, and big data wasn't really a thing back then. And even still then, the courts kind of looked at it and said, well, users might not want to give over this secure information. And it noted that in both, I believe, in both of the Ashcroft cases that came up, and perhaps even in Reno. And data collection now happens at a galactic level. Everything is collected, processed, used, sold, and data breaches are not slowing down. They're getting bigger. The NPI data breach from just recently is a good warning shot across the bow for creating treasure troves of this kind of data. So there are a few different ways that the legislatures have tried to address this. One of them is, we'll just have the government create a digital ID and it will all be handled by the government and therefore it will be more secure. Are they taking crazy pills or am I? Should we trust the government here?
No. And it's not even, and you can say that I think even if you love the government, right, you don't have to be an anti-government person to say that, but the government doesn't have a history of having great data protection practices either. And frankly, like it's really hard. I mean, it's the problem is there's when we talk about sort of data breaches, there are certainly people who don't try hard enough. There's also people who try really hard, but they're also really attractive targets to people who want the information. And so this is a game that security researchers on both sides have always played, and the government's not immune from this in any way. But I think that, there's two privacy aspects to this, and I think they're really important. And I mention this because one might appeal to the Washington Legal Foundation crowd more than the other. There's one which is sort of the data privacy aspect in terms of the information you would need in order to prove your identity. And so, for example, one of these things these bills do are really sort of incentivize and provide a market for data brokers that have as their business collecting a lot of data about individuals and then selling that data to people who use it, like people who want to know someone's age. The other privacy aspect is the ability to actually use the internet without your use of the internet being associated with you uniquely as a person. Right? This is also a data breach problem as well, right? But even if you don't want to regulate data brokerage markets, even if if you think those businesses should be able to operate as they do without limit, you would still be concerned about the privacy aspects of someone's internet use. And every time you are requiring someone to verify themselves, to sign in, even if it's only a one-time sign in, even if you have their usage linked either to some, to some chip on their that's not a technical term, to some token on their device or to their account or whatever, you are now enabling every intermediary along the line to know that they have used certain sites. And this to me is one of the really serious privacy harms, because what we get with age verification schemes and identity verification schemes is just losing the ability to keep your internet use history either anonymous, pseudonymous, or private.
Kate, did you want to jump in? Oh, okay.
Yeah, okay, I can. I would just say that like some of the bills that do this like try to pay lip service to what David just talked about a little bit, I think. And they say, delete the data. Like you can only use the data for age verification and then you have to delete it. And that doesn't work for a couple of reasons. The first is as an organization that has legal obligations, a lot of these websites are going to be like, well, I need to show somebody that I'm complying with this. If anybody ever comes to look, I need to have some sort of evidence that I'm doing this. And one of the ways to do that is to keep the data in order to show legal compliance. The other thing is, if you are using commercially reasonable methods that are run by a third party, there has to be a database against which you are checking the someone's age, however they are verifying it, either through facial recognition estimation or through checking it against vast troves of data or checking it against a database full of IDs. And so there has to be some data somewhere at all times to run these systems. And the other thing is oftentimes these obligations do not apply to all of the intermediaries along the chain, which I think is one of the points that David was getting at. So even if you can require the first party and the third party to delete the data, there are intermediaries in between that touch it, that have a reason and an incentive to keep it and sell it.
Do you mean to tell me, Kate, that state legislatures and attorneys general are not going to just accept the social media platform's word for it that they verified ages? Is that what you're telling me?
It's one of the things that I am telling you, yes.
Yeah, I find it perplexing that people seem to think that by putting one or two stops along the way in between the user and the ultimate service being used, that somehow that makes the data unlinkable and nobody can ever put the pieces together. It might take a couple extra minutes, but those pieces, if they're there, can always be put together.
And also, if I can just quickly highlight Kate's point about how these are really paying lip service, I think it's interesting to look at the specifics of some of the state laws, including, for example, requiring the deletion of all a user's data, not specific to the age verification process, as the privacy provision and looking at the penalty provisions, which often are much weaker for the privacy violation as opposed to the failure to engage in the age verification itself.
Yeah, that's a great point. And that actually, this all leads in very nicely to kind of the real red meat of the age verification, which is the impact on expressive rights. And that ties in with what David was saying about keeping your browser, browsing history, internet use history private. And one of the big reasons why the age verification mandates in the 90s were in the early 2000s were struck down is because the court found that they would deter users, adult users, from accessing content they had every right to access if they couldn't access it anonymously, particularly when it comes to sensitive content. People don't want that to be traced to them. And so, we're not exactly, at least with the social media laws, I guess I'll take one step back and say the laws say, like Texas HB 1181, that touch on, adult content. This is basically, it's transposed, onto the prior cases. It is very similar, and there isn't a whole lot of daylight in between the two situations. They're just taking another bite at the apple for the most part, hoping that technology had changed. But when it comes to the social media laws, there's a slight difference in between how, those old child protection laws and the social media regulations operate and what they target. And I think the social media laws, while they're all these laws have, big constitutional and expression issues, the social media laws are particularly damaging because now we are in a position where they're not just impacting the right to read anonymously, but because we use social media to speak so much, it actually requires you to give up your anonymity to talk to other people, which, doesn't make it any more unconstitutional, but it magnifies the unconstitutionality of it. Do any of you have thoughts on whether or not I'm right about that or wrong about that?
I think you're right about that. I think you're right about that, both in terms of what people are doing online, whether it's about anonymous browsing or anonymous speech. And I also think you're right about the breadth of the speech that's targeted by the laws. Clearly, that's true with social media age verification laws that are targeted at social media services. But I do actually think it's even true, at least to some extent, for the adult site regulations like HB 1181. Those laws typically regulate websites where 1/3 or more of the content is harmful to minors, irrespective of what the other 2/3 are. And so I think that also raises not just serious problems about the breadth of the laws, but it also highlights the ways in which this impacts adults' First Amendment rights, which I said before and you highlighted, but also kids, because kids have a right to access certainly social media, and at a minimum, the other 2/3 of what's available on even the adult sites, let's call them. That's probably a misnomer. And it raises the question of, like I flagged before, what does it mean to impose a standard that would apply to a 7-year-old on a 17-year-old, et cetera?
And this also really highlights sort of the differences between online age checking and the stuff that we get that people are fairly comfortable with is the in-person stuff, right? It's much different to briefly have to flash ID if you're within the age range where you might possibly be close to the limit. And that seems to be less of a barrier for people in terms of using services. And then that also usually in many cases only applies to only if you're buying a certain article within a store. So for the example, if there's a store that sells adult magazines, which I think still exist in print, then age might only be required to buy that, but not like every other magazine or the candy bars or whatever that are sold in the newsstand. And so that's much different. And I do think so Pornhub, for example, in its submissions to courts has some really good numbers. I actually look to have them exactly in front of me, but whenever age verification is required, it drives a ton of their users away. And it's not like their users have decided not to, I should say, first of all, Pornhub is a site, they verify age. Whenever a method, a particularly intrusive method, such as facial recognition or ID submission is required, it tends to drive their users away. That level, there's a certain threshold where people feel like, no, I'm not going to verify my age that way. And it's not like these people have decided not to look at sexual material anymore. They're just going to sites that don't care about complying with the law or really even care about keeping minor users off their sites.
Or just a Google search, which isn't covered by the law. I'm sorry, Kate or Vera, do either of you have a follow-up? I want to give you the option. So this leads into the question. What something Vera said is, talking about the impact on kids. That's another big difference between the the Communications Decency Act and the COPA cases, and this is that the minors don't have a constitutional right to access things that are obscene as to minors. That's established law. But here we have this these dual interests. You have the adult interest, but now you also add the First Amendment interests of kids. So do kids have First Amendment rights? What are their rights when it comes to social media? And I'm sorry, that is an exceedingly broad question that you could take days to answer, but whoever wants it.
Or you can just answer it and say, yes, kids have First Amendment rights. And they are essentially coextensive with adults. It's true that in the context of sexual material that is deemed harmful to them, they have their access to the knowing sale of that material to them can be limited. But that's essentially the only space in which the Supreme Court has said, yes, kids have slightly diminished First Amendment rights. They absolutely have First Amendment rights to access the plethora of things available on social media, from political expression to artistic expression, to gossip, to whatever it is that they want to do on social media. And one of the seminal cases that kind of explains this is Brown versus Entertainment Merchants Association, which was an attempt by, I think, California to restrict kids' access to violent video games in a way that tried to track obscenity laws, but clearly was about violence and not about sexual material. And in that case, the Supreme Court said, nope, you don't get to do that. We've said that there are diminished rates for sexual material, but not for any other types of content-based regulation, even when what you're trying to do.
And Brown versus Entertainment Merchant Association actually also deals with the question of whether parental consent can be imposed as a flat-out requirement across the board on minors before they can use social media accounts, does it not?
It does. I'll chime in because I think both Kate and Vera are having internet connection issues. So and this is an easy question. Yes, it does. And I also think it's so two things I want to highlight as well is that the harmful to minors doctrine as defined by Ginsburg in 1968 and then sort of Millerized after the obscenity test from Miller versus California in 1973 is really limited to patently offensive, and that's defined with respect to minors, sexual depictions. What we see with these laws is like really frequently is an attempt to define harmful to minors beyond the bounds of explicit graphic sexual representations to any type of either sexual or even non-sexual material that might be harmful to minors. As Vera said in Brown, the court said, no, this is limited to sexual material, but that doesn't stop these laws from being bad because they're capturing within this sexual health information, a whole variety of any material that pertains to sex that is not graphic sexual depictions, but is sexual in nature. And in fact, that seems to be the motivating force the explicit motivating force in many of the states that are regulating this. So I think it's worth noting that even though I think we all agree that there's a category of speech to which minors do not have a constitutional right of access to, for better or for worse. That's actually a quite limited thing that's rarely reflected, that these laws rarely are confining themselves to.
Yeah, that is absolutely true, and a great point. And to circle back just around quickly to the broader impact of these laws when they pertain to social media, I can think of any number of reasons why anyone, regardless of what they believe, where they are on the political spectrum, should be deeply, deeply concerned about losing their anonymity over. I'm thinking things like, if you're worried, I remember back in the day, the IRS scandal where, conservative groups, were accused the lowest earner of targeting them. I'm thinking of, people skeptical of the FBI. So, you have those group of people that are skeptical of rogue government agencies. Well, what do you think they're going to do if all of your internet browsing history, if they're really up to this stuff, kind of a bad idea to have this stuff floating out there. And on the other end, there's also things like authoritarian regimes and litigious, defamation suit filers who would love nothing more than to know exactly who to target and what for, and just go wild with it. And it really it casts a huge chill over online expression. Much, much greater now that we're using social media as we do. So to get a little bit in the weeds, but not too much, because we do really only have 10 minutes before question and answer. The Communications Decency Act and the Child Online Protection Act were again, as we discussed, limited to harmful to minors material. Some people argue that because these laws don't target, at least the social media laws, don't target any particular content or category or viewpoint of speech, that they're content neutral, and that they might not have to satisfy strict scrutiny. Maybe only intermediate scrutiny is necessary. What do you all make of that argument?
Well, I'll start. I think that's wrong, and for a lot of the reasons I just said, is that first of all, the CDA, just to clarify what Ari said, the CDA did not use the harmful to minors definition from Ginsburg-Copa, at least tried to. The CDA was more broader, as Vera said previously. It applied to offensive and indecent speech broadly, without linked to sort of the Ginsburg type harmful to minors formula. And one of these things Congress did in COPA, which was the follow-up, was to try and actually address that enormous source of vagueness that the Supreme Court called them out for. So I think that these laws, again, one of the problems, the reasons that they are content-based and subject to strict scrutiny is because they don't confine themselves to a very Ginsburg narrow type of definition. So there's that, as I said before, they want to see harm more broadly. A lot of times they talk about potentially harmful content. I believe that's the language from California AADC. And sometimes they even specify certain types of content. So those laws, I think, are certainly not. The other thing, though, is that it's hard to look at these laws because these laws affect all internet users, and this is something I'll pass on to my co-panelists, because they affect all internet users, are not only imposing a harm, because they have requirements for either age gating or some type of obstacle that an adult user has to go through in order to get online, because we don't have different doors on the internet for adult users and minor users. So when the law requires some type of gate, it's requiring it for all users. So what we're doing, we can't constitutionally impose a harmful to minors regime to adults. And so the reason why these laws get subject to strict scrutiny is because they are using harmful to minors to justify restrictions on adults' access or obstacles on adults' access. So even if a legislature has really confined itself to a category of speech which is not to which minors do not have a First Amendment right of access, the laws do not confine themselves to those minors' right of access.
If I could add something quick, hopefully my internet is working enough. Two things. that I agree with everything David just said, obviously. But also I would note harmful to which minors is one of the things that we don't ever dig into quite a bit. And have you proven that anything is actually causing the harm to minors? One of the things that came up in Brown versus Entertainment Software Association was, hey, you haven't even really proved that this is causing what you're saying. The harm you're causing, you're saying is being caused by violent video games. And we actually don't see solid evidence of this. There may be correlation, but there's not solid evidence. That's pretty much where we are when it comes to social media and harm to minors as of right now, minors in general writ large. But also, like, when you dig deeper into the data of what content is or is not potentially related to harms to minors, it really depends on which minors you're talking about, because minors are people. They are individuals who have individual experiences of the world, and some content that is useful to some minors is harmful to others and leads others down paths that should be that should experience intervention. These bills treat kids, minors, from 18 down to 7 as from 17 down to 7, as Vera noted earlier, often treat them as a monolith. Both in terms of their age, of which the age at which they are, both in terms of their maturity, but also in terms of, you know, the types of content that we can presume would be harmful to them in one way or another. And I think that all has constitutional issues with it, because the government is not showing that it is addressing a specific harm. In essentially any of these cases. But I have this kind of like vague cloud in my brain anytime I look at these statutes, because I don't understand what we are trying to do, or what problem we are trying to solve, except that there's a problem out there and it's scary, scary, scary. So we're going to regulate, and the easiest way to regulate is to ban and block access. But courts have consistently said we actually can't approach the issues you're concerned about in that way.
And, you know, it may turn out that research does pan out proving some harm to minor. But I think the important point here is, you know, when the government wants to step in and regulate, it has to prove it first. And the data is just too young at this point, in my view. Vera, did you have something to add?
I was just going to quickly to get back to the weighty question of strict scrutiny. I think most courts that have been looking at the social media age gating laws do apply strict scrutiny on the idea that social interaction, you have to look at the content of what is being expressed, what messages are being sent, and whether there's social interaction happening to assess whether or not the law applies to particular actors. But to the point that you and Kate were just making, arguably, even if all that applied were intermediate scrutiny, it still wouldn't pass through the gate, because, as you said at the beginning, it seems to be just, there's some big problem happening, we have to solve it, let's solve it with this nebulous and not targeted solution. And even under intermediate scrutiny, really, that shouldn't suffice.
Yeah, absolutely. And so to wrap up chilling effect, there's one thing I want to tie back in, which is the ways that legislatures have tried to address the privacy and security issues by saying, oh, you have to delete the data, you can't share the data, X, Y, and Z. Does that actually impact whether or not there is a chilling effect? You know, if the companies say, if they do have to delete it, and presume that they do, you know, does that mitigate the chilling effect?
I think you could imagine a universe in which it did. I think that, you know, I'm not here to say that any age verification law that applies to the internet is categorically unconstitutional in perpetuity, regardless of what technology exists in the future. That said, the Supreme Court has said in other cases like Denver versus FCC that even the possibility of the retention of data, whether intentional or unintentional, whether a bad actor or someone who just messes up, creates a chilling effect that has constitutional significance.
Yeah.
Can I add something quickly onto that?
Go ahead, please, Kate.
Thanks, David. I'm sorry. We haven't really talked about the fact that every single current method of age verification has an error rate. That means that you know, people who have the constitutional right to access the information can't. So it's not just the chilling effect. It is, if you are using a biometric age estimator, and you have a disability that makes your face look a particular way, such that you look older or younger than you really are, that error rate could mean that you, person who is actually well beyond 18, but look different than the biometric identifier can account for, you don't actually get to access constitutional content. If you are an undocumented immigrant and you do not have an ID, or a way to access an ID, you're also barred from that. And I think that has constitutional significance too. It's not just the chilling effect; it is also that this error rate, that the error rate, though it might look small, is actually gigantic. We're talking about millions of people that will not be able to access content.
And when you think about also, there's a huge number of U.S. households that have no minors in them, right? And like these laws apply and are burdening them as well. And there's people who share devices, right? And so anything that's device-based is like if they share with someone with a minor, and there's actually a lot of data about like grandparents and grandchildren actually sharing devices. And so it is really broad. And I actually think that chilling effects as a term gets a little bit of a bad rap because it seems like tremendously hypothetical. It's a logical fallacy. But I think what most people agree is that there's an actual inhibition of using services for fear of their data being mishandled. And so we're not talking about sort of a hypothetical thing. I think people are actually really concerned. And as soon as the material becomes sensitive at all, I think most users start thinking about, can this be traced back? Can this be traced back to me?
I think that's so right. Just to add to that, David, we were talking through how to think of the chilling effect in Free Speech Coalition versus Paxton, which is going to the Supreme Court this term exactly about age verification and the constitutionality of requiring age verification for websites where a third or more of the content is quote unquote harmful to minors. And one person on our team basically said, okay, you go to a pornography site and it asks for ID. Are you chilled? Do you think for a second whether or not you want to proceed on that website, even if you've been told that the data will be deleted? And everyone who was having any concerns about talking about a chilling effect on that call said, yeah, that seems pretty tangible and real to me.
Yeah, I think, also users aren't particularly thinking about what the law requires regarding data handling. All they know is that they are trying to do something that involves reading or speaking. They are being asked to identify themselves, and that causes that instinctive kind of recoil saying, oh, that's creepy. I don't want to do that. And in my opinion, that is the locus of the chill, is at that moment. Regardless of what the law says beyond that might, obviate that. Okay, so we are running short on time. I do want to give you, Vera, a chance to say a piece on the case that you have currently coming up at the Supreme Court, Free Speech Coalition versus Paxton, regarding the anti-porn law in Texas.
I don't need to say much, especially given the time. I think we've basically covered it. The Supreme Court is going to hear a case about whether or not such a law is constitutional, what level of scrutiny applies is the first question, and hopefully they'll also reach the question of whether such a law survives scrutiny, and hopefully we'll say no.
Yeah, and to tie in something that David mentioned earlier, with the Ginsburg standard of harmful to minors, that really is kind of center stage, because the Fifth Circuit in Free Speech Coalition, they really applied the harmful to minor standard to everyone to say, oh, there's almost no constitutional scrutiny, even though the rights of all adults are implicated. So that will be a big case, and we'll see if the Supreme Court remains tired of the Fifth Circuit's antics. So somebody asked a question which actually leads into the last part of what we had planned, which is, if not age verification, what advice would you give state lawmakers who want to regulate social media to keep kids safer? Is there a better approach, or one that's more constitutionally sound, or are their hands tied? And so that gets directly to the question of less restrictive means, which, if there are any, a law will not pass strict scrutiny. So, what can state legislatures or Congress do?
So I want to take this opportunity we've been talking about the law a lot, But I just want to put it out there because I know this is something we all agree on, but we haven't said it yet. To really question as a policy matter the wisdom of denying young people their autonomy to receive and communicate. And that's essentially what these laws do. We're doing it under a gloss of trying to protect them, as these laws have since 1868, which is when the English courts decided the Hickland case, which established really from nothing the idea that minors might be vulnerable to information. So I really think, I don't know how, I think one of the questions preliminary to that one is, why do what are they actually trying to protect from? As we talked about, is there an actual real harm there? What are the harms that how are we going to harm minors by denying them access to information, maybe information that their parents don't want them to see, or that they don't want to ask their parents for permission to see, or that that's not accepted within their community? There are serious harms on that side as well, and that's why these are difficult questions. So I really think it's worth questioning: do states do anything at all, at least when we're talking about older minors? And so there's that. To answer the question that was asked, if the state actually can articulate a harm, like a real harm that it's concerned about, then, and I'll just refer, EFF has written a lot about how we think that comprehensive data privacy regulation, which is, again, not privacy just for kids, but privacy but for all users, can address many, not all, but many of the concerns that states have about harm to minors. So I will recommend listeners to our website, where there's probably thousands of blog posts saying that. But that's one thing. And the other thing I just want to say is that I also be really skeptical about the efforts to address addiction online. And I am using scare quotes. And even some of the legislative efforts have moved off of the language of addiction because addiction researchers are saying this doesn't, they're not using sort of a clinical definition, and they talk more about compulsive use. And again, I really want to question the wisdom of that. We throughout history have had young people become very eager to receive information in a certain way. And I really find that sort of this idea of compulsive use it tends to be inherently linked to the content anyway. For example, we don't see people complaining about like their kids are reading too many, they're just on the Bible verse website all the time. I mean, it's really all relates back to, I don't like what they're looking on it, or, oh wow, they just can't stop doing their homework online. Like, it's not, so it's really hard, I think, in practicality to disassociate those types of things. We're concerned they're using the service too much with, we actually don't like what they're looking at on it.
Yeah, the concept of addiction kind of it really misses the point of media, which is to get people to consume more media. That is the point, is an attention game. Make your own adventure books are not addictive just because they keep you coming back for more. So go ahead, Vera.
Sorry, I was just going to say, I think also David's absolutely right. And that exactly that same motivation is leading legislators and other government actors around the country to enact book bans and to limit curriculum and to make it harder for kids to access any number of ideas, often in the gloss of sexual material. There are laws in South Carolina, Iowa, Florida, Tennessee that say that kids can't access books that describe or depict sex, read to its broadest terms, the dictionary, which defines what sex is, in school. So this isn't specific to the internet, and it is a motivation that, much as it may seem sympathetic, is really quite anti-democratic and illiberal.
Okay, great. I'll address one other question. Somebody asked, is web activity actually anonymous for most people? Perhaps not, but from my perspective, that kind of isn't the question. The question is whether or not whether it is actually anonymous in practice for those users. It's whether it could be if they wanted it to be. Do you all have any thoughts on that?
I think it's possible to use to use online services with some amount of pseudonymity or anonymity. It might not be bulletproof, but I think there are ways that people can, with current technology, confidently confidently do that, or at least, again, it's not 100%, but I think to the extent that the confidence to do that exists, these laws completely undermine that.
Okay, we are just about at time, so I want to give all three of you an opportunity for a lightning round concluding remarks. If you have any, don't feel like you have to, but if there's anything you want to get off your chest before this concludes, please feel free. Okay, hearing nothing. Thank all of you for joining us. I would encourage everyone viewing this webinar to go to the ACLU, CDT, and EFF's websites and look more into these fabulous panelists' work. They all do incredible work that you should definitely learn more about.
Thank you, everyone, for joining us today from Washington Legal Foundation. Just someone had asked in the chat if this is going to be available as a in-demand recording. It will be, most definitely, and I'll be sending out an email with the link to it. Fantastic conversation today. I really appreciate everyone's time, both of those who participated as speakers and those who took the time to watch this as well. So the next program in this series, the Tech in the Court series, is on October 15th. And it's going to be our second crossover program with the Tech Policy Podcast. And the title of that is You Won't Know the Answer Until We Come After You, Traversing the Crypto Regulatory Minefield, which will feature TechFreedom's Corbin Barthold and Coinbase's Chief Legal Officer, Paul Graywall. Again, thank you, everyone, for joining us today.